අබ්දුල්ල මං ඔයාලට හොට්ස්පොට් දීලා මම ලැප් එකේ එන්නම් මේ ඔයා හොට්ස්පොට් ගන්න.
හරි සචින් මට හොස්ට් එක දෙන්න.
සෞභාග්‍ය ඔයා මේකේ දිගටම ඉන්නව නේද? මං ඔයාලට කෝ හොස්ට් වෙන්න නිකන් හරි අබ්දුල්ලගෙන් මේ ලීවුනොත් ඔයා ගන්න.
හරි සචෙන්.
අබ්දුල් මේ ඔය සෞභාග්‍ය කියන එක්කෙනාට කෝ හොස්ට් පොඩ්ඩක් දෙනවද? සෞභාග්‍ය අබ්දුල්ලට මැසේජ් එකක් දාන්නකෝ.
හරි දාන්න.
අබ්දුල්ලා පටන් ගමු නේද ඉන්න කට්ටියගෙන් හරි.
All right. So then let's start the session. So some of the people are watching this on the YouTube channel as well as a live. So if those people have a question or something, just let me know through WhatsApp. Okay. Because yeah. Right. So today that we are planning to discuss about the terms of a contract. Okay, we are going to discuss on the terms of the contract. What are the important terms that we need to understand? So now let's understand about the terms of the contract. So I have already done this for our Tamil medium students, Tamil and Muslim students. So here that we are going to understand the complete syllabus of terms of contract. Now, in my note, in order to understand this easily, in my note, how I have categorized this term is into two categories. Okay. In order to understand this easily, I have divided the terms into two categories. So the number one is, we'll discuss about the category number one. So the category number one is about the express. We can divide it into two categories as express terms, comma, implied terms. Express terms, comma, implied terms. What do you mean by express terms? Express term means the terms of the contract, the important elements of the contract, the conditions of the contract are being communicated expressly, right? It has been communicated between the people who are there in the contract. Did you understand? So this can be either in the verbal format where both of the parties come to a contract after speaking to each other, right? Verbally communicating to each other. So this express terms can be either verbally, right? Vachikava, or else it can be in the written format, right? Likitava. So it can be verbally or else written, right? Express terms can be verbal or else written. Sometimes both the parties will come into the contract by verbally speaking to each other. For example, let's say that I am selling my car, then I have to meet with the buyer, and then both of us, the parties, can negotiate with the terms. We can speak to each other, right? We can directly speak to each other and come into the agreement. So the other one is implied. Implied term means what? We do not directly include this into our terms, but due to three main situations, these implied terms also take a part in the contract. Okay, we don't express, right, the terms. We don't directly put the terms into existence, but due to three main reasons, even the implied terms are valid. What are those three main reasons? Number one is implied terms can be there indirectly mentioned through the statutes, right? It can be mentioned through the statutes. So the terms which are mentioned in the statutes, we don't have to separately express it in our verbal or written agreement. It will be there. Did you understand? So in your contract, even though that you don't express it verbally or written, still it is valid. Okay, still it is valid. That is what we call as statutes. So for example, if we look into the sales and goods ordinance, right? If we look into the sales and goods ordinance, so the sections over there, that is kind of implied, right? We don't have to express it verbally or written. So when we are selling a good, though, when we are entering into a contract of selling good, we don't have to express it verbally, like look at here, right? In our contract, I'll be including the sales of goods and ordinance. No, there is nothing like that, right? It is implied where indirectly, right, it will be applied. It will be legally effective, legally binding between the parties. So as an example, if I take sales of goods ordinance, if I take sales of goods ordinance, the sales of goods ordinance section number 14 will say, right? If I take the section number 14 of the sales of goods ordinance, it says, right, it is about the description. So it is about the implied condition about description. Yeah, sure, right? Once after this, I'll upload this handout also. No issues, right? Okay, so section number 14 is about implied condition about the description. Now you are purchasing something, right? We'll say you are purchasing a bottle of milk. So the description says you have what? 200 milliliter, but once after that you measure it, you put into a separate container and measure, later that you find it is only 180. So then if you go back to your seller and you try to, we'll say that you are trying to take legal actions. So he can't say that, make a written nanny, make a verbal nanny. There is nothing verbal or written in this contract. No, you can say that, look at this section 14 of the Sales of Goods Ordinance. It is an implied term. It directly says that, right, the condition about the description, right? Implied condition about the description. And let's look at another section. Section 13.1. Section 13 subsection 1 says, seller has the right to sell. Did you understand? So the right to the seller to sell a product, it is not verbally or written. It does not have to be expressed. It is all about the implied term. Therefore, 13.1, seller must have the right to sell. Seller must have the right to sell. So this is the situation number 1. Implied terms come into the play by the statutes. Okay, implied terms come into the play by the statutes. And also in the case laws, we can understand where the implied terms are very important, right? Where the implied terms are very important. So the case we can understand here is Liverpool City Council. Liverpool City Council versus Irving. So I can remember, like, here the lift is not working. Now we'll say that you are getting a apartment on a rent, right? And the lift is not working. So the person can't, right? The person who gives the apartment on rent, he can't come and say, no, about the lift, we haven't mentioned in our contract. We haven't expressly came into an agreement about that, right? They can't complain like that, because the thing is, here it is an implied term, right? If you get an apartment on rent, it is implied. You expect the lift to work, right? Or the staircase to be in a good condition. So they can't come and say, no, we gave you only the house on rent, the room on rent. So in our contract, there is nothing about the lift or the staircase, right? There is nothing like that, Kela. They can't complain, because it is being understood under the case laws, right? So the case laws also mentions about the implied terms. So that is the number 2. And number 3, normally when it comes to a custom, so this can, customs mean sirit pirit kyanne sirit pirit the monarika, right? So customs, when it comes to customs, it will get changed from country to country. Normally when you come into an agreement with the country's setting, with the country's custom setting, you have to obey that, and it is an implied term. You don't have to mention it in express terms or verbally or written. It will be binding on the parties. Did you all understand? Therefore, for that we can get a case, Smith versus Wilson. So if you have time, just go through the cases. But here it's enough to remember, when it comes to custom, it's an implied term. Therefore, finally, express terms mean what? Where the parties express to each other. It can be either verbally, right, vachikawa, or else written, likitawa tiyanna puluwan. The other one is implied terms, where the parties understand about the terms in the contract, right? They imply. That means it does not have to be openly or directly expressed to each other, either in the written or the the verbal format. It will be applicable statutes, case laws, and customs. Okay. Now with this, you know that normally when it comes to a contract, it's better if we can have a written contract, right? It's better if we can have a written contract. But there are some situations, normally the parties enter into the contract through an oral agreement. It is valid. Did you understand? There's no hard and fast rule saying that the agreement needs to be a written one. But when it comes to there is a rule called parole evidence rule. There is a rule called parole evidence rule. You can find this in the evidence ordinance, right? Sakshi Anya Panata evidence ordinance, section number 92. If you have the evidence ordinance, just go through that quickly, right? If you have the evidence ordinance, ටිකක් බලන්න, right? Go to the section number 92, everyone. Right? Section number 92. Go to the section number 92. So evidence ordinance section number 92, right? It says, when terms of any such contract grant or other disposition of property or any other matter required by law to be reduced to the form of document have been proved according to the last section, no evidence of any oral agreement shall be admitted between the parties to any such instrument or their representatives for the purpose of contradicting, varying, adding or subtracting. Hari. Now we'll say an agreement is completely in the written format. Sampurne written format. In that situation, we can't bring the oral evidences in order to explain it or in order to change it. Am I clear? So in order to interpret it, in order to subtract a term, we can't use the oral evidences. Sampurning liyalanang tiyenne, we can't use the oral evidences in order to interpret or subtract it or add it or do something. Simply, we can't change it using the oral evidences. Right? So since I have done this for our Tamil medium and Muslim students, I'll be adding some Sinhala words also here and there. Right? Therefore, I remember, if the contract is completely in the written format, okay, if that is completely written, totally written, you cannot bring the oral evidences in order to interpret it, in order to change it or do something. Did you understand? Therefore, parallel evidence rule means if a contract is completely or totally written, other oral evidences cannot be used to interpret it, right? You can't use the other oral evidences in order to interpret it, right? In order to interpret it. Okay, right. Therefore, so we'll say another situation where, right, the contract is half written and half oral, right? Bhagaya clear naha. If it is half or partially written, at that situation, this parallel evidence rule is not applicable. At that situation, you can bring your oral evidences as well. Did you understand? So parallel evidence rule is applicable only if a contract is completely or totally written. Okay, සම්පූර්ණයෙන් ලියලා තියෙනවා නම් විතරයි මේක applicable. But if it is partially written, if it is half written, then this parallel evidence rule is not applicable. So you can bring the oral evidences, right? But if the contract is partially written, only half written, then this rule is not applicable. Only if it is completely written, then this evidence ordinance section number 92 rule is applicable. Did you understand? So just try to remember that. Okay, so that is all about our category number 1. This is all about our category number 1. So category number 1, once again, express terms in verbally and written. Implied terms, you can divide it into 3 categories: statutes, case laws, customs. And the parallel evidence rule, you can find that in the section number 92. Now we will move into the second category. So if you have any question, you can ask from me. Now let's move into the second category. Okay. All right. Category number 2. So when it comes to category number 2, there are 4 types of terms. One is the conditions, right? One is the conditions. The other one is the warranties. Condition, warranties, and then the innominate terms, and then the exemption clauses. All right. So what do you mean by conditions? So condition means the most vital terms. Did you understand? Most important or vital terms, right? Vadagatma, the most important terms. Did you understand? For example, right here we can understand it through a case. So the simple definition that we can give here is conditions are the most important or vital terms. Did you understand? Now, the parties, if one party breach the condition, what will happen? This can amount to terminate the contract. Am I clear? The parties can terminate. එතනින් ඉවරයි. You all have violated the condition. Therefore, done and dusted. With that, ඉවරයි. Finished. Contract can be terminated. Therefore, breach of condition can amount to termination of the contract. Did you understand? If a party breach the contract, then what happens is the entire contract can get terminated. That is the seriousness of this condition. So here the case is Possards versus Spurs. So here a singer, right, he does not participate in the first day of the event. Now, when the when the musical show goes for around, we'll say 4 or 5 days, first day is like one of the important day, no, right? The first day is a kind of a condition. If that person does not come on the first day, then they can terminate the contract. That is what happens in this, right? The person was unable to, the singer, right? The person was unable to come on the first day for the concert, for the musical show. Then what happens is that a contract can get terminated, right? Contract gets terminated. Why? Because first day, right? Participating in the first day, it's a condition. It's a most important or vital term. Did you understand? So we can quote a case, we can write the case of this. Possards versus Spurs. All right. So the next one is, in my note that I have prepared, the second one is warranties. Warranties are not that important as conditions. එච්චර වැදගත් නැහැ, right? Not important as condition, right? It is important, but not that important like the condition. Did you understand? Therefore, we'll say you go into a contract and the warranty, right? A warranty term get breached, then you can't actually resign the contract, right? You can't cancel or you can't terminate the contract. Did you understand? So that is the kind of then both the parties should come into an agreement or do something. No parties will get the right to cancel. No parties will get the right to resign the contract. Did you understand? Therefore, warranties means less vital terms. Okay. So parties will not get the right to resign. Right? Warranty එකක් breach වුණා කියලා you can't cancel, terminate කරන්න බෑ. For example, we'll say in a musical show, the singer is not participating for the rehearsal. Rehearsal is not as important as the first day in the concert, no. Right? Rehearsal එකට ආවේ නැහැ කියන්නේ concert එකේ first day එක වගේ නෙමෙයි. Did you understand? So you don't participate in the rehearsal does not amount to a breach of condition. It will amount to a breach of warranty. Did you understand? Sometimes out of the payment that they are planning to make, maybe they can reduce the payment or do something. Did you all understand? Therefore, you have to understand breach of warranty, parties will not get the right to resign. The example is Bettini versus Guy. Bettini versus Guy. In this case, also I think the singer, he does not participate in the rehearsals, but parties does not participate in the rehearsals does not amount to a breach of the condition. Did you understand? Therefore, rehearsal is something less important than the first day, no? So you have to understand, if it is most important, it's like condition. If it is not that important, right? It is good if that is there in the contract, but if it is not that important, that is warranty. Am I clear? If it is 100% important and if it is the most vital term, then that is the condition. If that is not that important, it is warranty. Did you all understand? Therefore, in a contract, you need to figure it out. Whether is it a condition or is it a warranty with the scenario, right? With the case that they give. All right. Hurry. Now, what is this innominate terms? I'll give a note on this as well. What I have written. Innominate terms mean you can't differentiate whether this is a condition or warranty. Hari, පැහැදිලි කමක් නැහැ. Warranty the condition the right. You don't have a clear image. You can't figure it out separately. You can't distinguish, right? You can't differentiate it. At that situation, what is the solution? Only solution is court will look after that. Court will decide whether is it a condition or is it a warranty. Did you understand? Therefore, court will decide whether this is the most important term, then it is a breach of condition, or is it a less important term, then that is a breach of the warranty. Right? අපිට කියන්න බෑ. Court will look after that issue. Court will look into that issue. We call it as innominate terms. Another. Right. Now, what are these innominate terms? We will write down a small note, what I have written in my note. If the terms cannot be distinguished as whether conditions or warranties, then the decision lies upon the discretion of the court, right? උසාවිය බලාගනි. If we can't differentiate, if we are lost in finding whether this is a condition or a warranty, court will look into that issue. In such situations, the court has the responsibility to grant the decision whether conditions which are important have been breached, or warranties which have been breached, right? So in this situation, court will look into this. So example is Hong Kong shipping versus Kawasaki. Hong Kong shipping versus Kawasaki. Did you all understand? Therefore, that is all about the innominate terms. That is all about the innominate terms, right? So if you have any question out of these things that we have discussed, just let me know, right? YouTube එකේ live බලන කට්ටියත්, if you have any issue, just let me know.
අබ්දුල්ලා
Okay.
අබ්දුල්ලා ඔයාලා අන්තිමේට කිව්ව කේස් එක චුට්ටක් පැහැදිලි කරනවද? ඒක ඇත්තනම් ඒක ඇයි මේකට වැදගත් වෙන්නේ කියලා පොඩ්ඩක් ඒ කේස් විතර පොඩ්ඩක්.
ටිකක් ඉන්න. මොන කේස් එකද මේ සචින්?
හොංකොන් කේස් එක.
හොංකොන් කේස් එකද?
ඔව්.
හොංකොන් කේස් එක නම් මේ සචින් මම බැලුවේ නැහැ. මොකද මම සාමාන්‍යයෙන් මේ ඉගෙන ගත්තී අර කේස් එක ගැන එච්චර මේ අර ඩීටේල් කරන් ඉගෙන ගන්නේ නැහැ. ඉතින් අර මේක ඉනොමිනේට් ටර්ම්. එතකොට මේකට උසාවිය බලාගනි කියලා ඊට පස්සේ කේස් එක ලියනවා. මම කේස් එක බැලුවේ නැහැ. ඒ වුණාට මම කේස් එක බලලා ඒකේ වොයිස් නෝට් එකක් හරි ගෲප් එකට දාන්නම්. හරිද?
හරි අබ්දුල් thank you.
හරි. මේ කේස් එක නම් මට ඔළුවේ තියෙනවා. ඒ කියන්නේ අර බෙටින් versus guy එකේ අර මේ රියර්සල් එකට ආපු නැති එකයි අනිත් එකේ මේ first day ආපු නැති එකයි. But I will check the innominate this case and let you know. Right? Right. Now let's move into the exemption clauses. Exemption clauses වලට යමු. Right? මොකද්ද මේ exemption clauses? Right. Now, while දැකලා ඇති in the car parks and all, there are some like notice, right? Park at your own risk, right? park at your own risk. Now, you go to the Cargill's Food City, you park your car, but they have mentioned park at your own risk. So what is the meaning? The Cargill's Food City management is not responsible if something happens to your car. Did you understand? Something happens to your car, right? For example, you keep the bag on the counter, right? You keep the bag on the counter, you give the bag to the counter, and they say, right, we are not responsible for something happens. Did you all understand? Therefore, not responsible for lost bags or lost articles or anything. So that is like the other party try to refrain from any later obligations. Did you understand? Later liability. They are trying to get off from their responsibility. Am I clear? එයාලා වගකීමෙන් එළියට එන්න බලනවා. Did you understand? So if they don't put the notice like park at your own risk, and if something happens to your car, you can go and sue them. Did you understand? But here they can show, look at here. Park at your own risk, but you have parked and something happened to you. That's it. Did you understand? Therefore, exemption clauses means the contract, the party of the contract, they are trying to get off from their obligation. They are trying to get off from their responsibility. Okay, now when it comes to this exemption clauses, this can be under two main, right? There can be two main categories. So we'll write down a small note. This is a situation in which the contractual party is released from the contractual duty. Okay, so from their contractual duty, they are getting free. They are getting released from that. Did you understand? So they can't take the responsibility. They can't take the responsibility. Simple. Now that can be limiting clause. Limiting clause means what? Limiting clause mean, right? For example, now that you keep the bag to the counter and they say, if something happens to your bag, up until the value of around 10,000, we can replace. Am I clear? 10,000 වෙනකම් වෙන ඕනම risk එකට අපි වගකීම දෙනවා. But beyond that, right? If the value is beyond that, 10,000ට උඩින් තියෙන දැන් ඔයාලා laptop එකක් තියලා යනවා. That you keep a laptop inside your bag. So that is anyways more than 10,000 no. Company says, the counter says, we are not responsible for that. Did you understand? But 10,000ට අඩුවෙන් ඔයාලගේ මොන හරි වුණොත් we are responsible for that. That is a limiting clause. They limit the responsibility. Am I clear? So this is not completely they come out of their responsibility, from their liability, from their obligation up to a certain limit. Did you understand? Imposing limits in the exemption clauses. For example, we'll say any damage to customers property will be limited. I'm going to leave a bit. I'll watch the recording. All right, Isuru, no issues. But you will be doing the past paper questions, ne?
Yes, can you just put a message to the group?
Sorry?
Can you put a message to the group when you're done? I'll immediately join. I'm really sorry.
All right, Isuru. Okay.
Bye.
Therefore, imposing limits, right? Any damage to customers' property will be replaced, value up to rupees 1,000, right? 1000 වෙනකම්, right? Rupees 1,000 වෙනකම් we are responsible. ඒකට උඩින් මොන හරි වුණොත් we are not responsible. Am I clear? The other one is they don't take the responsibility. Sampurning, they don't take the responsibility. We can call it as exclusion clause. Completely they come out for their responsibility. Park at your own risk. Am I clear? ඔයාලගේ භාණ්ඩවල මොකද්ද වගකීම අපි බාරගන්නේ නැත. Am I clear? We don't get the responsibility at all. Okay, therefore, this is exemption without limits. Exempted without limits. Am I clear? Without any limits, they are exempted. Exempted without limits. So mostly are car park this one only. Did you understand? Exempted without the limits. Okay. Now we will understand. Now other concepts we are going to learn through the cases. Am I clear? Cases වලින් අපි බලමු other concepts ටික. Cases. All right. Case number 1. Case number 1, right? Oli versus Marlborough Court. Now, Oli versus Marlborough Court, from this case, what is the rationale behind this? What is the thing that we can understand? Now, we'll say that you go to a hotel. In this case, that is what happens. You go to a hotel and you book a room and you get a ticket, right? You get a ticket. Nothing is mentioned about the responsibility, about the parcel, or about your properties or anything. But then you go to the room. Okay, so finally, we'll say that something happens and someone has stolen your bag, right? So stolen your bag. Now you go to the management and say, look at here. Now someone has stolen my bag. A theft has happened. Now you all have to give me money, right? Or that I can sue you. But what they say is, no. Look at the door inside your room. Look at the door. We have mentioned we will not take the responsibility for your bags or for your properties. Is that okay? No. The conditions, the exemption clauses should be mentioned at the time of contract. When you are paying money to book a room, they have to mention that. At least ticket එකේවත් ගහලා දෙන්න ඕනේ. They should mention. Now you are signing kind of an agreement, we'll say they have to mention that. Or they have to say that, right, sir? This is the case. If something happens to your bag or containers, we will not take the responsibility, your property. Then that is okay. But later, if you go into the room and something happens, someone has stolen your bag, and then only that you see, all right, there is a sticker pasted on the door where we will not take the responsibility. Is it enough? No. Right? Contract එක වෙන වෙලාවේ, right? room එක book කරන වෙලාවේ යාලා කියන්න ඕනේ. මොන හරි වුණොත් අපි වගකීම බාරගන්නේ නැත. Right? After that, right? room එකට ගියාට පස්සේ අලවලා තියෙන ඒවා exemption clauses නෙමෙයි කියලා Oli versus Marlborough case එකේ කියනවා. Did you understand? Therefore, at the time of contract only, they need to mention the exemption clauses. Exemption clauses cannot be mentioned somewhere else. So that is kind of fraud, right? අර contract එක වෙන වෙලාවෙ කියන්නේ නැහැ. එහෙම කිව්වොත් sometimes we don't go to the room, no. Right? We don't book. එතකොට මේ වෙන වෙලාවෙ කියන්නේ නැහැ. පස්සේ කියනවා මේ කලවල තිබ්බ අරහෙ තිබ්බ මෙහෙ තිබ්බ. So that is being mentioned in the Oli versus Marlborough court. So the rationale behind this says exemption clauses should be properly communicated and mentioned. Should be mentioned කියන්නේ should be mentioned at the time of contract, when that contract is happening, at the time of contract. Did you understand? ඕනම් මේ case එකේ facts ටිකත් බලා ගන්න, but that is the simple idea. Number two is now exemption clauses should be properly communicated and understood. Now they should tell you these are the exemption clauses and you need to understand. Okay, that is the number two. The case is L.E. Strange versus Graucott. Okay, so according to this case, what can we understand? Exemption clauses පැහැදිලිව communicate වෙන්න ඕනේ. අපි ඒක තේරුම් ගන්න ඕනේ. If not, අපි අමාරු වැටෙනවා. We will fall into issues, problems. Therefore, exemption clauses should be properly communicated and understood later by reading it properly, reading the condition. හරියට read කරලා තමයි sign කරන්න ඕනේ. Did you understand? If there is any exception clauses. Right. Number three is now the case that we are going to understand is Thomson versus LMS Railway. So in this case, one lady, as I can remember, takes a ticket and they have mentioned the condition, exemption clauses in the ticket, but she is blind. She can't read. And then after something happens, I think the bag is getting stolen or something, she comes and complains, no, you haven't mentioned. You haven't mentioned about the exemption clauses and I am blind. I don't know. Is that excuse? No. Right? If the party, if the railway, they have given the proper notice, reading that or not is your problem. You are blind or not is your issue. Am I clear? If they have given a reasonable notice, then that is legally binding. Am I clear? Espenne, ahunne, danne, read karene, adalane. Did you understand? If they have given the reasonable notice, then you are legally binding. That is what mentioned in this case. Therefore, should read and sign if the reasonable notice is given, even though there is a disability, right? Even though there is a disability. Espenne කියලා කියන්න බෑ after something happens. Either you have to give it to someone and get it read. Did you understand? So that is what mentioned in this case. Exemption clauses. Did you understand? Right. Now, one party has given the reasonable notice. Did you understand? One party has given the reasonable notice, but you did not read it properly. Did you understand? You did not read it properly. Okay, but is that okay? Then later can you come and say, no, I did not know this. Am I clear? එහෙම කියන්න බෑ. For example, the case is Parker versus Southeastern Railway. Right? Easy to memorize also. In this case, Parker is giving a bag and then later they lost the bag. Then Parker comes and says, you took the responsibility for my bag to the counter, in the counter. Then the railway department says, look at the back of your ticket. Right? Look at the back of your ticket. We have given a reasonable notice. අපි මේක කියලා තියෙන්නේ කලින්ම. We have given the reasonable notice. You haven't read that. Am I clear? ඔයා හරියට කියුවේ නැහැ. So then you can't come and complain. Did you understand? You can't come and complain. So that is being mentioned in this case. Therefore, if the party rely on exemption clauses, railway department, the party rely on exemption clause, එයාලා reasonable notice එකක් දීලා තියෙන්නේ. Right? Clause has given reasonable notice of it. Then the protection, right? කවුද ඕක මේ වගකීම ගන්න ඕනේ? It will be there, right? Protection of the clause will be available to party once communicated. Did you understand? දැන් law faculty එකේ counter එකේ bag එක තියෙනවා, right? කියමු කියලා ටිකට් එකක් දෙනවා කියලා. ඒ ටිකට් එකේ ඊපස්සේ ගහලා තියෙනවා. මොන හරි වුණොත් බාකියෙන් බාර ගන්න නැහැ කියලා. පස්සේ ඇවිල්ලා අහන්න පුළුවන්ද? බෑ. You have to read that. Did you understand? So the law faculty counter has the protection, right? එයාලට ඔකේ ආරක්ෂාව තියෙනවා by the exemption clauses. Am I clear? You can't come and later complain, no, I did not read this or anything. Okay, therefore they have the party have the relevant the protection from that. But in another case, they say that the exemption clauses after the contract එක උනාට පස්සේ mentioned in the voucher, in the invoices, in the ticket, it is not enforceable. Am I clear? ඒක අර පාකර් කේස් එකත් එක්ක ටිකක් ගැටෙනවා, right? it contradicts with the Parker case because in Parker case also අර ticket එකේ දීලා තියෙන එක මෙයා කියුවේ නෑ. But in the fifth case, which is Chapelton versus Barry UDC, right? He gets the chair from the Barry UDC, I think a council. Then what happens is the chair collapses, the chair breaks. But in the invoice, in the ticket, it has mentioned, right? So we will not take the responsibility කියලා. Did you understand? It can be an exception. ඔව් සෞභාග්‍ය. ඒක exception එකක් කියනකට වඩා මේක අර ටිකක් contradict වෙන situation එකක්. මොකද දැන් පාක කේස් එකේ අපි කියනවානේ හරියට communicate කරාට පස්සේ මෙයා ටිකට් එක කියවුවේ නැති එක මෙයාගේ issue එක කියලා. නමුත් චැපල්ටන් කේස් එකේදී අපි කියනවා මේ එහෙම අර contract එකෙන් පස්සේ invoice වල voucher වල තියෙන exemption clauses පිළිගන්න බෑ කියලා, right? So that is kind of contradictory. Even when I was learning, right, I just went through these cases again and again, but still that confusion is there. Did you understand? So case එකට අනුව ඔයාලා argue කරන්න, because in law there is nothing called right or left, no, right? හරි මේක හරි මේ වැරදි මේක කියලා නෑ. How far you can argue? ඔයාලට කොච්චර argue කරන්න පුළුවන්ද? You can get it right. Okay, therefore exemption clauses theory එකක් විදිහට මේ ඉගෙන ගමු. Exemption clauses after the contract, okay, right, after the contract in vouchers, invoices are not enforceable. මේ case එකේ කියන්නේ එහෙමයි. Not enforceable. The fifth situation. Did you understand? And the other situation, right? For example, now using the exemption clauses, something fraud can happen. Did you understand? ඒ කියන්නේ fraud, right? මොන හරි fraud එකක් වෙන්න පුළුවන්. Exemption clause පාවිච්චි කරලා අර ring ගන්න තැන් තියෙනවා. Did you understand? Therefore, that is Curtis versus Chemical Clearing and Dyeing Company. So එතකොට this case what happens is I think a girl is giving one of her dress, right, for a laundry. So there is an exception clause. If something happens to your dress, we will not take the responsibility. So then the girl is asking, what type of risk? What type of things that you don't take the responsibility? So then they say, if something happens to your button, right, for the sequins or buttons, we don't get the responsibility. But later, what happens is due to a dye, something happens to her dress. Then when she comes to claim, the company says, no, look at here. We have mentioned clearly, if something happened, we don't take the responsibility. But then the girl says, no, when I asked from you, you all told that that you will not take the responsibility only if something happens to the button. Now why it is like this? Hari? So in situations of using the oral communication, they are misrepresenting, right? In situations of oral misrepresentation or frauds using exemption clauses, other party is not bound. Hari? Now මේක වෙන්නේ සිද්ධිය මෙහෙමයි. සරලව මම සිංහලෙන් කියන්නම්. දැන් ඔයා යනවා laundry එකට ඔයාගේ මේ t-shirt එකක් අරගෙන. හරිද? එතකොට ඒකේ කියලා තියෙනවා මොන හරි t-shirt එකකට වුණොත් වගකීම අපි බාරගන්නේ නැහැ කියලා. එතකොට ආය අහනවා මොන වගේ වගකීමද? t-shirt එකට මොන වගේ දේවල් වුණොත්ද ඔයාලා බාරගන්නේ නැහැ කියලා. එතකොට යාලා කියනවා මේකේ මේ button එකට sequins එකට මොන හරි වුණොත් තමයි අපි වගකීම බාරගන්නේ නැහැ කියලා. හරිනේ. දැන් orally යාලා misrepresent කරලා ඉවරයි. පස්සේ බලනකොට ආයෙ ඇඳුම ගන්න යද්දී වෙන ඇඳුමක පාටක් දැන් ඔයා දීලා තියෙන සුදු පාට ඇඳුමක් කියලා කියමුකෝ පස්සේ වෙන ඇඳුමක පාටක් ඕකේ ගෑවිලා තියෙනවා එතකොට අහනවා බලන්න මං දෙනකොට ඔයාලා කිව්වේ බටන් එකට මොන හරි වුණොත් තමයි වගකීම බාර ගන්න නැහැ කියලා දැන් ඔයාලා වගකීම බාර ගන්න ඕනේ කියලා එතකොට යාලා පෙන්නනවා මේ බලන්නකෝ අපි මේ ලස්සනට දීලා තියෙන මෙතන හරි වගකීම බාර ගන්න නැහැ කියලා නමුත් එයා කියනවා නෑ ඔයාලා මං අහද්දි කිව්වේ වෙන එකක්. Did you understand? Therefore, in situations of oral misrepresentation, වාචිකව සිදුවන මේ frauds, at that situation, other party is not bound. Am I clear? එතකොට මේ කර්ටිස් කියන ගෑනු ළමයා නෙවෙයි වැරදි කරලා තියෙන්නේ මේ කම්පැනි එක. Did you understand? So that is the situation. May exemption clause කියලා there can be a lot of frauds like this. Another one is exemption clauses must be clear. Exemption clauses must be clear. මේකට case එකක් තමයි ශාව කච්චේරි versus දේව බාලන්. ටිකක් බලන්න ඕන නම් case එක, but case එකේ facts මම එච්චර බලන්නේ නැහැ. මොකද case එකේ facts ම ලියලා ඉන්න බෑනේ. කොහොමද ලියන්නේ නැහනේ. right? තියෙන නීතිමය principle එක තමයි ලියන්නේ. එතකොට ශාව කච්චේරි versus දේව බාලන්. දේව බාලන්. හරි. Exemption clauses must be clear. Clearly මේක කියලා තියෙන්න ඕනේ. Okay. And then මේක ටිකක් පරණ scene එකක්. Right? I'll explain in English first and then I'll explain in Sinhala because for Tamil students already that I have explained this. Exemption clauses cannot breach the fundamental obligations. ඒක තමයි case එක. That means, for example, we'll say that you are hiring a security to protect your company, right? If something happens, to protect your company, to security guard to your factory. Did you understand? Now, security guard cannot say, if something happens to this company at night, right? I will not take the responsibility. If something happens to this factory due to fire, I will not take the responsibility. If something happens to the factory due to the employees will say mistake, I will not take the responsibility. They can't say that. Why? Because you are hiring a security for what? For the security of your factory. So he has the fundamental obligation to protect your factory. He can't come up with the exemption clauses, right? For the fundamental obligation, they can't come for the exemption clauses. Did you understand? Can the Keel say that, right? For the product that you are buying, we are not responsible? No, because you go to the Keels and buy, they have the fundamental obligation to give a proper product for you. Therefore, this is mentioned in the case of Smeaton Hanscope. Right? Smeaton Hanscope. But in the current context, this is different. In the current context, they say, no, even for the fundamental obligation, right, there is an exemption. No issues, right? In the current concept, every fundamental obligation cannot be fulfilled. Therefore, during some fundamental obligation, there can be exemption clauses. Example is Photo Production Limited, right, versus Securico Transport Limited. Did you understand? So මෙහෙමයි scene එක. දැන් ඉස්සර නම් fundamental obligation එකක් exemption clause එකක් හරහා breach වෙන්න බෑ. ඒ කියන්නේ fundamental obligation එකකට ආරක්ෂාවක් ගන්න බෑ මේ exemption clause එක පාවිච්චි කරලා. කියමුකෝ අපි security guard කෙනෙක් hire කරනවා අපේ factory එක ආරක්ෂා කරන්න. එතකොට security guard ඇවිල්ලා කියන්න බෑ මං නිදාගද්දි මේකට මොන හරි වුණොත් මං රැට ඉද්දි මේකට මොන හරි වුණොත් factory එකට එහෙම නැති වුණොත් මේ මොන හරි මේ වෙන employees ලගේ mistake වලින් මේ factory එකට මොන හරි වුණොත් මම වගකීම බාර ගන්න නැහැ කියලා කියන්න බෑ. right? මම රැට හොරු පැන්නුත් වගකීම බාර ගන්න නැහැ. එහෙම ඒව කියන්න බෑ. right? Because security guard ගේ fundamental obligation එක ඔක protect කරන එක. හරි? එතකොට දැන් Keels company එකට කියන්න බෑ ඔබලා අපෙන් මේ මිලදී ගන්න භාණ්ඩ වලට අපේ කිසිම මේ responsibility එකක් නැහැ කියලා exemption clause ගහන්න බෑ. මොකද ඕක fundamental obligation එකක්. right? මූලික එයාලගේ වගකීමක්. මූලික වගකීම වලින් මිදෙන්න exemption clauses පාවිච්චි කරන්න බෑ. right? නමුත් සමහර අවස්ථා තියෙනවා දැන් මේ photo production case එකේ මේකට exemption එකක්. එහෙම නෑ මූලික වගකීම් වලින් උනත් මිදෙන්න exemption clauses පාවිච්චි කරන්න පුළුවන් අවස්ථා තියෙනවා. ඒක case එකට අනුව වෙනස් වෙනවා කියන එක තමයි මේ Photo Production Limited and Securico Limited case එකේදී කියන්නේ. Did you all understand? Therefore, normally the rule is exemption clauses cannot breach the fundamental obligation. මූලික obligation වලින් මිදෙන්න අපිට exemption clauses දාන්න බෑ කියන එක. නමුත් සමහර අවස්ථාවලදී with the discretion of the court මේක වෙනස් වෙන්න පුළුවන්. දැන් මේක අපි ඉගෙන ගන්න එක එහෙමම ඇප්ලයි වෙන්නේ නැහැ කිසිම තැනකනේ. මේක වෙනස් okay. Had a small connection issues. Sorry for that. All right. එතකොට in order to refrain from a fundamental obligation, in order to get protected from a fundamental obligation, you can't use the exemption clauses. But in this case, the court grants the exemption clause protection even though there is a fundamental obligation breach. Am I clear? එතකොට make sure that you read the case if you all want. So exemption clauses means like this. Did you understand? But remember these exemption clauses has to be clear. Oral misrepresentation. මේවා ඉතින් වෙනස් වෙන්නේ නැහැ. නමුත් මේ වගේ දේවල් ටිකක් වෙනස් වෙන්න පුළුවන්. දැන් ඒ වගේ තව මේකක් දැක්කද? Look at here. දැන් මෙතන මේක කියනවානේ මෙහා ටිකට් එකේ කියන එක හරියට කියුවේ නැති එක මෙයාගේ ඉෂුව එකක් කියලා. නමුත් මෙතන කියනවනේ එහෙම ටිකට් වල දෙන එක enforceable නැහැ කියලා. එතකොට ප්‍රශ්නෙට අනුව තමයි ලියන්න වෙන්නේ. Did you understand? Therefore this is a very kind of a sometimes it is subjective concept where based on the question that we need to write down and answer. Did you understand? Therefore category 1 express terms where you are verbally or writtenly express that. Implied means to the statutes, case laws, customs, we have to follow that. Parallel evidence rule means what? When the contract is completely written, you can't bring the oral evidences. And then category number 2, condition, warranties, innominate terms, and the exemption clauses. So what are the conditions? Right? Important terms. If you breach that, the party can terminate the contract. Warranties mean what? Less vital terms. Innominate means you can't figure it out whether it is a condition or a warranty. So court has the discretion. Exemption clause means what? In order to protect yourself from a contractual obligation that you are putting exemption clause. So these are the cases. So you have to mention in at the time of the contract, it should be properly communicated. Even though there is a disability, you have to read it properly. That means somehow that you need to follow that. And then if the party has given a reasonable interest, then they have the protection. And then exemption clauses after the contract are not enforceable. And then if there is any oral misrepresentation, then the party cannot get the protection from the exemption clauses. And finally, it should be clear and it cannot breach the fundamental obligation. But currently, there are some exemptions as well. Did you all understand? So that is all about terms of contract. Now, whatever the question they ask, you can use these things and you can write down a good answer. මේ case ටික දාලා ඔළුවේ තියෙන දේවල් ටිකත් එක්ක හොඳ answer එකක් ලියන්න පුළුවන්. Right? All right. So if you have any question, මගෙන් අහන්න පුළුවන්. If not, මේක හොඳට තේරුණා නම් මට yes එකක් දාන්න. If you understood, put yes. Right? YouTube එකේ බලන කට්ටියත්, right? Live එකේ ඉන්න කට්ටිය put a yes. Okay, nice. So next, Isuru will do the past paper question.
අබ්දුල්ලා මේ
Okay.
අබ්දුල්ලා මේ ડોකියුමන්ට් එක දානවද ගෲප් එකට?
ඔව් මම මේ ලයිව් එක ඉවර වුණායින් පස්සේ මම ડોකියුමන්ට් එක ගෲප් එකට දාන්නම්.
හරි.
හරි. Okay, so හැමෝටම තේරුණා නම් then I'll ask Isuru to continue from here. Then thanks for being here with me. Now I'll ask Isro to continue the session. Give me 1 minute, right? Don't leave the meeting, be in the meeting. Right, Isro, that I'll give the host to you, okay?
Shall we take a little break because it has been 1.5 hours now?
Yeah.
If you don't mind. Guys, shall we can you all take a break for like 10 minutes and then we'll start again. If you don't want a break, you can just go through the question. There are two questions that I have put to the group. So just go through them a bit and I'll be explaining an answer to them. So join again in 10 minutes. I feel like starting immediately is going to be a bit confusing.
ඉසුරු left වෙන්න එපා.
Okay, let's do that. Y'all can take a break, by the way. Y'all can leave if you want. Yeah. Sachin, you can start recording. Is the recording on? All right.
ඉසුරුව මකර
Oh, අපි පටන් ගමුද record කරන්න?
පටන් ගමු.
Ah,
ඔයාට හොස් දීලා නේද?
මන්ද record කරන්න බෑ.
එහෙමද? එහෙනම් මට හොස් දෙන්නකෝ.
මට අර record කරන්න දෙන්නත් පුළුවන්.
හරි රෙකෝඩ් කරන්න දෙනවා ඔයාලට.
Yeah. Right, guys. So, I'm doing this in the form of questions because I feel like elements of contract, a lot of you are confident. Okay, let's start again. Right. So the reason that I'm doing this as questions and not as theory is because I feel like a lot of you are already confident doing the theory aspect of it. You might have studied these stuff on your own when we were doing the assignment. So I'm only going to be doing questions related to elements of contract, the remaining part of it. There are two questions that I want to focus on today. One of them specifically focuses on offer and invitation to treat. In the last recording, you might have noticed that we did touch up on this question, but I'm going to deal with it in a bit more detail today, right? I'm not going to be doing the consideration part of it. I'll be doing the intention aspects and stuff like that. So first question that we're dealing with is 2023 question 1. So usually you might have noticed when you're going through the past papers as well, the first question is what we get from elements of a contract, right? The next is usually terms, but I can never say for sure because there was one year where the second question was from the postal rule only. So, it depends, but usually the first question is elements of a contract. Okay, so I'll read through the question. I'm sure you have read through it as well. On the 5th December 2023, Nilu placed an advertisement in the newspaper indicating that she was selling an antique chest for 100,000 rupees. Mali responded on the same day by telephoning the number indicated, stating that she's willing to buy the chest, paying 80,000 rupees in cash and giving an antique vase that she said was 20,000. So you can see that there was an advertisement being placed. Now we can question whether if this is an offer, doing will be an acceptance, but is it an acceptance? No, because it will count as a different version, right? So Nilu is saying, I will sell this for 100,000, and then Mal is responding, if there is any lagging issue, please do let me know. And Mal is responding saying, I will pay 80,000 in cash and 20,000 as a good, right? So if this was an offer, then this would be a counter offer, but we'll deal with that later. So after that, the call was received by Nilu's secretary, Amila. So when someone's secretary or someone is representing another party, we call that party an agent. And usually contracts, if they are a authorized agent, whatever the agent says has the same validity as the offerer themselves. So let's say we have party A who's the offerer and party B who is the offeree of A, and A has given C the power to make decisions in her behalf. So when the offeree accepts something and C says, yes, I accept it, that means it's almost as if A said it. So C represents A. Does that make sense? I hope that makes sense. So if anywhere in the question, it is like at least suggested that the secretary, Nilu did not give the secretary any power to make this decision, then the secretary did not have the power to accept. Just keep that in mind, right? But here we can understand that she's acting as an agent who agreed to what Mali said. Amina sent Mali the draft contract by email asking her to fill the details. So what's happening here, if I'm just going to draw this, we have Nilu who says there's a antique, antique chest that she's willing to sell for 100,000. Then this is Nilu. Then we have the offeree no, let's not already define her. Then we have the other party who is Mali, who responds and says, yes, I'm willing to buy this, but I can't give you 100,000. I will give you 80,000 plus an antique vase, right? Was it a vase? Yes, plus a vase. Then we have Nilu's secretary who says, okay, that's a good deal, but you have to send that deal in an email with your details, placing your signature on the document and send it to us through an email. So here she's making another offer, right? So the secretary says, okay, that sounds good enough. Just send it through email. But this is where the issue starts again. Mali had some problem with her email account and therefore printed and signed the contract, scanned it through her phone and sent it through WhatsApp. So the way that the secretary wanted this communication to happen was through email. The expectation was for it to happen through email. But because of some technical issues, it couldn't be sent through email, but it was sent through WhatsApp. So there's another issue that we have to deal with. Is there a valid contract made, right? Because the way that was supposed to happen versus the way that it happened are two different things, right? Then, however, before Amira could read the messages, he lost his phone and could replace it only after the 10th December. Because of this WhatsApp message was not reached. So while this whole thing was happening, the WhatsApp message did not reach, and someone else called Pravina made a contract with Nilu, and Nilu sold the chest to Pravina. So what is our question now? Firstly, focusing on the aspects of offer and acceptance, discuss whether there is a valid contract. So let's try to break that down. Okay. Now, what's asked from us in the first question is offer and acceptance, validity of a contract. When we are figuring this out, we first have to break it down and figure out, okay, what was the offer? What was the acceptance? Now, let's first look at the very first thing that's there here, which is an advertisement. What is the general presumption when it comes to an advertisement? An advertisement, the presumption is not an offer. We talked about this yesterday. We say an advertisement is usually presumed to be an ITT for several reasons. So this is explained in my answer here. Now, in the case Partridge versus Crittenden, if you remember, this is the case to do with the bramble, finch, hens, and the cocks. It was established that an advertisement for goods are an invitation to treat. The reason that an advertisement becomes an invitation to treat is because usually a seller has limited stocks, and if an advertisement is an offer, he will be bound to sell to every person who accepts. Now, if we look at our case here, this person, Nilu, only has one antique chest, right? So say that this was an offer. Let's assume that this was an offer. What will happen then? Anybody who looks at the advertisement and anybody who accepts it, that means Nilu will be bound to them. So if 100 people accept it, that will be 100 contracts. And Nilu can't say, no, I can't have a contract with you. I didn't make an offer, right? So that is why we say it is not an offer, but rather an ITT. Why? Because there are limited goods and you can't be unlimitedly bound to so many people who accept it. So usually when you say something like, oh, in Partridge versus Crittenden, it was established that advertisement for goods are invitations to treat and not offers, it's better to give a rationale because that's what they expect. So the rationale here that we are going to give, rationale means the justification or the explanation, is that the seller has limited stocks and he should not be bound to everybody who accepts. Moving on, there are other explanations that we can give as to why advertisements are considered to be ITTs and not offers. Again, these things we talked about yesterday, which is puffery or exaggeration. And we talked about this with the example of PepsiCo, right? So I'm not going to go into detail there as well. The rationale that we're going through here is advertisements are meant to attract customers. They are not meant to well. While presumption is an advertisement is always an ITT, it is still rebuttable in the case that there is a clear intention to be bound. And the example case for that is Carlisle versus Carbolic Smokeball. What happens in this case?
The company makes a unilateral offer to the rest of the world. What does that mean? In the case, they have a clear intention to be bound, right? They are not saying like, how am I think you guys know this case, so I don't have to explain this in detail. You just have to mention if there's a clear intention to be legally bound, that means the ITT in the advertisement converts into an offer. So what we have to look in this case is, was this an advertisement which is an ITT or an offer? Now, this advertisement doesn't say anything about, oh, the first person that messages me, I will definitely give the antique chest to them, or a person who is part, like, he doesn't give any definite terms, and he doesn't say, I'm willing to be legally bound to anyone who complies to this, right? He just says, she just says, I'm willing to sell this antique chest. So this is not an offer, but an ITT. Something put to the chat. I'm sorry, that was confusing. One second. Gotcha. Can you slow? Yes, surely I can do that. So let me slow down and explain what I did again. Let me just go through it again. What I said here so far is the differentiation between an offer and an ITT. I said when it comes to an advertisement, the general presumption is that it is an ITT and not an offer. The reason, we talked about 3 different reasons. Firstly, sellers have limited stocks. Secondly, there can be puffery or exaggeration. Third thing I have not mentioned here, advertisements are meant to attract customers, not create legally binding contracts. So because of those 3 reasons, advertisements generally are ITTs, not offers. However, advertisements can convert into offers if there is a clear intention to be legally bound and the terms are clear enough. So we have to look at this case and figure out, are there clear enough terms, and is Nilu planning to be legally bound? When we look at this, it doesn't seem so. So we can establish that there is no offer, but rather an ITT. So here, since the advertisement is an ITT, no, I haven't mentioned it here. So here we can use advertisement lacks these elements. What elements? Being definite enough in terms and being intending to have legal intentions. Why did I mess it up? Let me write that down. 2 things to establish here. Firstly, we have to establish that there are clear, definite terms. Secondly, intention to be legally bound. Intention to be legally. Since both of these things are not there, we can say it's not an offer, but an ITT. I'm sorry if I messed that up for you guys. Secondly, moving on. So if that was not an offer, so what is the offer then? Then the offer would be Mali's interaction. When Mali looks at the advertisement and takes a phone call on December 5th, that becomes an offer. So here, instead of accepting the terms that were there in the ITT, she makes her own unique offer. She says, I can't take this for 100,000, but I will take it for 80,000 in cash with an antique vase. So this is her making an original offer. Okay, what is Amila or the secretary's reaction to this? Instead of accepting this offer, she does not immediately accept. Amila makes a counter offer. So what happens here? The first advertisement is an ITT. Then we have the call, right? The telephone call by Mali. The telephone by Mali is an offer. Then the secretary says, yes, that sounds good, but send it to me through an email under an electronic signature under this form. So when the secretary says this, she's making a counter offer. So when Mali sends the email, sends the email, she did not, but let's assume she did send the email, that would be acceptance. So hopefully this makes sense how the whole thing breaks down. We have the advertisement as an ITP, the telephone call as an offer, the secretary saying send it to me through an email as a counter offer. And if the person did send the email the correct way, that would amount to acceptance. Okay? Met, that would mean there was an agreement. And if other things are met, that would mean that it's a contract. Okay. So now let's look at the counter offer. In the case Hyde versus Wrench, it was established that if an offer is met with a counter offer, the original offer is destroyed. So when the secretary makes a counter offer, let's say Mali says, look, your secretary still agreed, right? She did tell that I have to send it through an email, but she still agreed that she will buy this from me. So that is acceptance, right? I made an offer, she agreed, so that is acceptance. You cannot say that. Why? In Hyde versus Wrench, it says, if you make a counter offer, the original offer cancels off. If the original offer cancels off, there cannot be any acceptance. So this is like very tricky because it says here that Amila agreed to what Mali said. This is not acceptance. Why is it not acceptance? It's because Amila still made a counter offer. Because she made a counter offer, the original offer that Mali gave was cancelled off, which means there cannot be any acceptance. So what's left now is a counter offer, and then Mali would have to accept it by actually sending the email. If that is confusing, please put to the chat. I will explain it again. So what I'm establishing there is, even though Amila did agree to this, that is not acceptance because there was a counter offer that was established in Hyde versus Wrench. Moving on, what we have here is conditional acceptance. So what does that mean? This acceptance is conditional upon this counter offer. So the offer that Amila makes says, you have to send it through email, filling this form with the electronic signature. If you do not fit in at least one of these conditions, then it is not acceptance. What the case that establishes that is, oh, why haven't I mentioned it here? It is the mirror role image case. Let me check what the case is. If someone knows, can you quickly put it to the chat? The case with the mirror role image. Ah, yes, Neil versus Merritt. Thank you. Neil versus Merritt. In Neil versus Merritt, it says acceptance should be unequivocal or it should follow the mirror rule. What does the mirror rule mean? The mirror rule is something like this. Let's say the offer has term 1, 2, 3, 4, and if there is to be acceptance, there must be agreement to 1, 2, 3, and 4. If this party disagrees to one term, there is no acceptance. The offer and the acceptance should perfectly mirror each other. That is what was established in the case Neil versus Merritt. Okay. So what were the terms that were in this counter offer? It should be through email, it should be filling this form, and it should be under an email signature. One of these terms was not fulfilled. What was that? The email term. Because she had some sort of an issue with her technical aspect, instead of sending it through email, she decided to send it through WhatsApp. Okay, so now we have to think, was this a term which, which was like a mandatory term that you had to follow, right? So here we have to look at this case, Manchester Dawson Council, Commercial and General Investments. The simple case name for this, if I'm not wrong, is the Manchester Dawson case. That's how I have seen some people refer to it. So I think that's a shorter name for it. So in the Manchester Dawson Council case, what happens is the court makes a differentiation. They say there are some modes of communication which are mandatory, not modes of communication, some modes of acceptance which are mandatory, some modes of acceptance which are this directory. So let me explain this with a different case, right? Let's say that we have party A and we have party B. Party A says, okay, I will sell you 10 pieces of iron. Oh, what's this? 10 pieces of iron for 100,000. If you accept, if you accept, through telex, let's say, if you through telex, party B accepts it. However, instead of sending it through telex, they decide to send it through WhatsApp. In this case, the court would say this was a mandatory clause, right? Or according to what they say here, a mandatory instruction. In order to accept, party A said, if you are going to accept it, you have to mandatorily send it through a telex. However, party B sent it through WhatsApp. That is not acceptance. So when we're talking about acceptance, there can be some instructions which are mandatory instructions. If the mandatory instruction is not followed, there is no acceptance. However, there can be instances where the instruction is not mandatory, but rather directory. Let me give an example for that. Instead of saying, please accept it, 1 second. Okay, so instead of saying, if you accept, please send it through WhatsApp, please send it through telex, you can say, if you accept, please communicate your acceptance as soon as possible. Please communicate your acceptance as soon as possible. Now, when you say that, you are not giving a mode, right? You are just directing, just communicate it as soon as possible. If you do it through WhatsApp, that's good. That's good. It's not mandatory. You can send it through Instagram if you want, as long as you communicate it to me in a reasonable way, right? So what is established here in this case is there are two types of instructions when it comes to acceptance, right? There are mandatory instructions, which is a specific method and no other. But if it's a directory instruction, some equally advantages is permitted. However, we have to look at what is. Now, when we are figuring out what is equally advantageous versus what is less advantageous, there are two things that we can consider in this case. In this case, would WhatsApp be better than email? If you logically think about it, is email as equally advantageous as WhatsApp? We can say it's not. Why? There are two arguments that we can give here. There are way more that you can give if you think about it, right? One of the arguments that I say why WhatsApp is not equally advantageous as email is because the photo of a printed document is less distinct than a digital file. Now, when she's saying, send it through me through email as a digital file, she's expecting something which looks a bit more neat and is a bit more clear, right? When it's a digital document, it's a bit more clear. However, how is Mali sending this? She's printing the document and then signing it. It is less clear then, right? The quality of the photo itself is going to be less clear. So from that aspect, there is less advantage sending it through WhatsApp compared to sending it through email. The second thing, email is a server-based communication method. Now, when you are sending it through WhatsApp, you send it to one singular person, and if that person loses their phone, as it happened in this case, what will happen is the acceptance is lost. However, sending it through email is less risky, right? Because even if you lose your phone, that doesn't mean the entire acceptance and the entire document is lost, because you can still access it through email. So there are two disadvantages that come with sending it through WhatsApp instead of sending it through email. And thereby we can say WhatsApp is less advantageous than email. Now there are two arguments that you can make depending on where you stand with. On one hand, you can say that this was a mandatory instruction. I am on the opinion that this was a mandatory instruction because Amila doesn't say send it through email or any other method. No, she says send it through email. So that sounds like acceptance should be made through email and no other method. Because of that, I believe that it is a mandatory instruction. But if you still believe it's not mandatory, it might be directory, she might be hinting at other modes of communication as well, you can still go with another argument and say, okay, sure, it was directory, but still there was a heavy disadvantage of sending it through WhatsApp compared to sending it through email, and thereby still there is no contract, there is no acceptance. So if it was mandatory, there was obviously no acceptance. You can use an argument like that there was no acceptance. I hope that may not. Please put to the chat. I will repeat again. Right. So then receipt rule. Ignore this blue color one. That one is wrong. I wrote the that instance. But let's look at what the receipt rule is. Now, you might know what the postal rule is, right? The second that you put the letter to the post, that is acceptance. It does not have to reach the other party. Receipt rule is the opposite of the postal rule. That means the party must read the form in order for there to be acceptance. But still, receipt rule is not really held when it comes to instantaneous communication. Instantaneous. We say that the postal rule does not apply and the receipt rule applies. So let's take, for instance, this case, the Brims case. The actual case name is quite long. This is the shortened name, right? The Brims case is to do with a ship, right? So I have written the case down here. It's to do with a ship. Now, the ship is to be sold. This is acceptance, but to do with withdrawal, but still you can use it for acceptance. The ship was to be sold and the company decided to withdraw their offer, withdraw the acceptance in the last moment, right? They sent their withdrawal letter through a telex message. However, the telex message was not read because the staff in the company decided not to look at the telex machine. In this case, the court said the staff's negligence is not the other party's fault. The message was sent during office hours, and that's enough, right? As long as you sent the communication during a time where the other party would have received it, that would mean the receipt rule is met. That does not mean the other party has to read it. As long as you sent it at a time that the party could be able to read it, that is good enough. So what is the opposite of the receipt rule? Opposite in the sense, what can happen on the other hand? If this party, let's say the party A who was sending the acceptance, sent it at night. They sent their acceptance at night. Was their acceptance by party B? No. Because you can't read the message at night. Office hours are closed. Only if they send it during morning and the message was like sent to B, that's good enough, right? Even though B did not read it, according to the receipt rule, as long as they could have read it, there was acceptance, right? So in the Brims case, what happens is the message arrived during office hours. Even though the message was ignored, the recipient is at fault and acceptance is considered. In a postal rule, what does it say? The message does not have to reach the person, right? As long as the message was put to the post, that's enough. That's in non-instantaneous communication. Remember, in non-instantaneous communication, acceptance can be said at the point that you put the post. But in instantaneous communication, acceptance will be according to the receipt rule. That is when the acceptance reached you. It should reach you, right? It can't be lost in mail or something like that. It should reach you. It doesn't matter if you read it or not. Now, in this case, how can we talk about it? The phone was lost. So it didn't reach, it probably reached the person's WhatsApp. It reached their WhatsApp, but phone was lost. Phone was lost. Now let's assume the email part අපි එක සම්පූර්ණයෙන් ignore කරමු. Let's ignore the email was there in the first place. Let's say that the secretary said, send your message through WhatsApp and we will, your acceptance will be considered. In that case, if the message was reached through WhatsApp and the phone was lost, too bad, acceptance should be considered, right? Because the phone being lost is, Nilu's Amali's fault, right? That is not Mali's fault. Amali, wait, what's the secretary's name? Amila. If the phone was lost and Amila wanted the message to be sent through WhatsApp, that is Amila's fault. However, Amila asked Mali to send it through email because she did not want a risk like this to happen. So in that case, Mali is the one who is at fault. I hope that made sense. If it was established that it could be sent through WhatsApp and the phone was lost, then Amila is at fault. But when Amila sent it through email and then the phone is lost, then Mali's fault. Hope that made sense. I hate that the name sounds same. Okay, moving on. The second contract, right? So we can basically say, since the acceptance and when the acceptance was sent, it was not received as well, there is no contract between Mali and Amila. So because there's no contract, the contract made between Nilu and Pravina becomes a valid contract, because in that contract, everything, right? You can see the offer is made by Pravina, saying that she's willing to buy. So that's the offer. Nilu says, okay, I will sell it to you. So there's an acceptance. And then drops the money off at Nilu's house. There is like, the whole thing is complete, right? There's consideration, there's offer, there's acceptance, and that contract is valid. The previous contract became invalid because acceptance was lost in mail vageka, right? I hope that made sense. Do y'all want me to run through it one more time? If anyone tells me run through it one more time, I'll do it, or I'll move on to the next question. Please put to the chat if you want me to go through it one more time. No? Okay. We'll move on to the next question. Give me a second. Please read through the question on your own because I read really fast. Okay, guys, I hope you read through the question. I'm going to start. So this, if I'm not wrong, yes, it's a 2024 first question. I'll read through it one more time. The University of Colonia is interested in repurposing one of its old halls into a state-of-the-art auditorium. The has put up a notice on the face page calling for closed tenders. Immediately as the word closed tenders come to your mind, the case that should come is Havela versus Royal Trust, okay? For the least expensive building contract. It was specified that the bid can be sent through the social media platform WhatsApp. Bid can be sent. Special bid can be sent. Martin received many bids. One of the bids he received was from the company VBuild, which stated that it was willing to enter into a contract for 15 million rupees or for 100,000 rupees lower than the best tender. What do we see here? A referential bid. Referential bid. The lowest tender received from Martin was 12 million rupees by Builders Ltd. However, when Builders Ltd made the bid, they had not seen the notice. Okay, so they had made an offer without seeing the notice, right? Right. It was based on their initiative that they made the bid and sent it on a different social media platform named Viber. And they had sent it in a different platform as well. Regardless, Martin decided that Webuild's quotation was the most lucrative and entered into a contract with it. So they went with the first one. Builders Ltd accused Colonia of entering into a contract in contravention of its offer, and then it was unfair for Webuild to couch their offer in the terms that they did rather than providing a fixed amount. So they say referential bids are unfair, and it's very, very unfair that you're giving the bid to someone who made a referential bid. Okay. To this, Webuild argues that the notice that was put on Facebook was a display and therefore was only an invitation to treat. And the wording of their bid was simply smart business. Webuild also argued that the fact that Builders Ltd did not submit their bid in response to the notice but on their own initiative was a major flaw. So, what are the things that we have to address here? Firstly, is there an offer or an invitation to treat? And secondly, was there a valid contract that was formed between the parties? Right. So let's first establish the first thing, which is offer versus ITT. Okay. So this whole thing is just what an offer is versus what an ITT is. A quick reference to it again. An offer is a definite proposal made by one party, which is immediately legally bound upon acceptance. On the other hand, invitation to treat is an indication of the other party to make offers, invitation to make offers, while the person inviting may choose to negotiate or accept. Right. Now, when it comes to this is a tender, right? A tender situation. We have Spencer versus Harding as one case we talked about for tenders being ITTs or offers. Now, in the case Spencer versus Harding, let me take the case out. I'm going to explain the case facts because I feel like it's a bit important. This is not a tender situation, but rather an auction situation. But just keep in mind, auctions and tenders are basically the same thing. In tenders, you are just asking someone to give your lowest price, but in auctions, you usually try to go for the highest price because you're selling something, right? Okay. So in Spencer versus Harding, which is an auction, the auctioneer sent out a circular and they say, we will take the bids of whoever we want, which was thereby a no reserve one. Right? So when there is a reserved auction or a reserved tender, then it is an offer. Remember, if it is reserved, it is an offer, but if it is no reserve, if it is not a reserve, it is ITT. What does reserve mean? Reserve means saying something like, I will give it to the highest bidder. I will give it to the lowest bidder. I will give it to the bidder who first says 100,000. It's reserved, right? You give a condition upon which you will comply with, right? No reserve means you're like, okay, whoever I wish. So when you're saying, okay, I'm going to give it to whoever I want to give it to, then it is an ITT because you're leaving it up to yourself, right? Remember we said yesterday, if it is definite, then it's likely it's an offer. And if it leaves no power, to the offerer to decide, then it is an offer as well. So here in Spencer versus Harding, it was a no reserve case. Basically, they didn't say we are giving it to the highest bidder. So in such a case, even though you give the highest bid, you don't have to sell it to that person. You don't have to, because it was an auction, you don't have to sell it to the highest bidder. So basically what was established in Spencer versus Harding, if it is a no reserve auction, you don't have to give it to the highest bidder. However, in this case, it is not a no reserve auction. It is a reserve auction because as you can see in this case, it says for the least expensive building contract that is reserved, right? Okay, so under that means it's not an ITT, but rather an offer. So here, this person says, Webuild argues that the notice was an ITT and not an offer. That is wrong, right? It is an offer, but not an ITT. Is there a case that establishes it? Yes. In the case Havela Investments versus Royal Trust, the case says that we will take the highest offer. The House of Lords looks at that and says, look, when you say that you're going to take the highest offer or the lowest offer or something like that, it's a unilateral offer that you're making, right? It's not an ITT. So we can use these two cases. This case which talks about if it is not reserved, it's an ITT. And this case which says if it is reserved, it is an offer, in order to come to the conclusion that what the notice is ultimately is an offer, not an ITT. So very simple explanation you have to give for this entire thing. You can add this argument as well, which is the objective person argument. So we usually say, if it is not explicitly mentioned or if we have to interpret something, we look at what a reasonable person who looks at this contract would see, right? A reasonable objective person who looked at the notice would not think, the university is going to give it to whoever they want, even though they say that it's the least expensive building contract, right? They will think the university said it's the least expensive building contract, and thereby they will give it to the least expensive building contract. So because of that, it's not an ITT, it's an offer. So we have to look at it on the objective person principle, right? Okay, very simple. Answering the first question is not hard. Second, both they are a valid contract form. Here, there are several things that we can look at. One thing that we can look at for this is the idea of was there proper acceptance or not. Again, we are referring to the same principles as the case before, right? Remember in the case before, it was sent it to us through email, but the person sent it through WhatsApp. In this case, it's the person saying send it through WhatsApp, but here the person has instead sent it through something called Viber, right? Instead of sending through WhatsApp, they send it through Viber. Again, remember the case before, what was the principle that we used? We used this idea of was it a directive instruction or was it a mandatory instruction, right? When we look at the wording here, it says it can be sent through එවන්න පුළුවන් WhatsApp වලින්. So that is not mandatory. Sending it through WhatsApp is not mandatory, but rather directive. So what we have to establish here is, first we say, because of the word can, it becomes directive. Sorry, it becomes directive. Now we have to look at is it more advantageous? So is it equally advantageous, or less advantageous where there is no acceptance? If it is equally advantageous, we say that there is acceptance. You can say, I think, if Viber was a platform that is commonly used by parties as much as WhatsApp is, then it is equally advantageous. However, if Viber is a platform that these universities do not interact much with, and it is common knowledge that WhatsApp is more used by universities and people in general, it is less advantageous. If it is less advantageous, there is no acceptance. If it is equally advantageous, there is acceptance. So that's one thing that we can look at for there to be a valid contract, right? But that is when we are talking about this other party, which is Builders Ltd. So one problem that Builders Ltd did was not sending it through WhatsApp. So we established that there could be acceptance if Viber is something that everybody uses. There could not be acceptance if Viber is something that everybody does not use. Did I mess that up? It's fine. Now, there is another issue that they had. They did not send an offer looking at the notice, right? They did not send their offer like after looking at the notice and saying, oh, they have opened up for bids. They sent this offer on their own, right? This is something that they sent absolutely on their own, and it was not in reliance of it. So even if they sent it, so now we established not an offer, sorry, acceptance. Since we said that the advertisement or the notice was an offer, the bids that are being sent are going to be acceptance. And if you know, there is one rule in acceptance that says acceptance should be in reliance of the offer. If acceptance is not in reliance of the offer, it is not valid acceptance. What is the case law for that? Crown versus Clark. In Crown versus Clark, what basically happens is there is a whole police investigation that's going on to catch two murderers, right? And Clark is one of those suspects. So now Clark does not want to get caught. He goes to the police station and he acts as a witness and he gives all the information and he tries to save himself. He only goes to the police station and gives this information because he wants to save himself, not because there was an offer that was out there saying that if you give information about the murderers, we will give you an award, right? So he was not giving the information relying on that notice, relying on that reward notice. He was giving information simply because he wanted to save himself. In that instance, the court said, since you did not accept the offer and you simply went individually and did it for a different reason, there is no contract. Similarly, in this case, Builders Ltd sent the bids not as a bid. They sent it on their own. They didn't reply to the notice. So that means there is no acceptance because that did not happen in reliance of an offer. So the principle that you have to remember, acceptance in ignorance of an offer or acceptance without relying on an offer is not acceptance. So in that sense, this would not be a contract. Next question that we have to look at is, what about VBuild? Now, VBuild does a referential bid. We talked about this yesterday, but I'll repeat it here. A referential bid is not allowed when it is close bids. A referential bid is when you are referring to someone else's bid and saying, oh, I'm going to give 100,000 more than whoever the lower than the best bidder. Or I'm going to give 100,000 more than the other bidder, right? You can't refer to that. Why can't you refer to that? Just think of the rationale here. The reason that referential bids are not allowed is because it will be impossible to determine a bidder. Why? It will spiral infinitely. Let me give you an example. We have A, B, C, and D. And we have a university, let's say this university, who wants the lowest bidder. And this is a closed bid system. A says, I am going to give 100,000 or 10 rupees less than the lowest person. B says, I am going to give 90,000 and 10 rupees less than the lowest person. Then he says 80,000 and less than the lowest person. He also says 100,000 less than the lowest person. If all of them do that, you have to keep on counting 10 rupees less than the lowest person to check who on earth will get this bid. Not 10 rupees, let's go like 10,000 because then it will be like harder to calculate. You have to keep on spiraling and figuring out who has the least. You have to keep on doing this calculation forever. That is not what you want a close bid for, right? So referential bids are usually invalid because it creates an impossibility on picking a person because you are going to keep on spiraling and determining who has the lowest. So in that case, you have to rather give your lowest bid. So you say 80,000, you say 100,000, you say 90,000, and you say 100,000. Who the lowest bidder is C, and thereby C should get the bid. That is a valid bid. Right. So you can use this case, Havela Investments, and say, since this party did basically cheated by giving a referential bid, that is not considered to be a valid acceptance. Thereby, this is not acceptance. On that end, the final conclusion that we have is VBuild's contract is invalid because there's a referential bid. Because there's a referential bid. And that is according to the case Havela. Builders Ltd, despite having the best price, failed because they did not act in reliance of the offer. And also, they failed to follow the specific communication requirements. You can say this. You can also bring up the other argument that we brought before. We can say, even if it was not mandatory, and it was, I forgot the word now. Wait. Yeah. What was the word? Yeah, directory. I keep saying discretionary. If it was not mandatory, but rather it was directory, you can say if Viber is still less advantageous, because of that reason as well, they have failed to follow the specific communication requirements. So thereby, this company also, we builders also failed to have a valid contract. I hope the summary made sense. Guys, do you all have any questions at all? Or anything to add? Carson, was there anything I messed up?
Nope.
I'm guessing that's a no because I didn't hear it.
I
Okay.
said no.
Okay. Right. So that's quite it. Those are two questions. The other question is to do with intention. I did send this to the group, but let me just go through it really fast. Anushini is an enthusiastic collector of antique furniture. Ben had an antique telephone that was passed down by his family. One thing to note here, Ben is her cousin. Anushani always pestered Ben to give it to her. One day, Ben agreed to give the telephone to Anushani in exchange for the assurance that she would no longer complain or bother him about the other antique items within the family. Moments following the exchange of the telephone, Ben told Anushini that aside from the telephone being of great antique value, it even works well for communication purposes. This is part of representation, but that's not important. However, when Anushini went home and plugged it in, the phone did not work. Now, Anushini feels that she could have benefited more from obtaining the antique coffee table in Ben's house as opposed to the telephone. Anushini is now trying to return the telephone and ask for the coffee table, citing that a contract was not binding and an informal agreement between family members. Ben argues that there is a contract and there was a clear intention to enter into legal relations. So, what do we have here in the contract? We have an offer that is made by Ben, and there is acceptance by Anushini. There is consideration as well. What is the consideration? Anushini says that she will stop bothering, which is an interesting consideration. This doesn't count as consideration because it's not monetary. But let's say, so she says, I will stop bothering you. Ben says, I will give you the antique, what was it? The antique telephone, right? I will give you the antique telephone. So then Ben says, this was a valid legal contract. Anushini says, no, it's not a valid legal contract. Take this telephone back. Give me your bar. So she's like literally breaking what she promised, right? She promised that she will stop bothering him. He gives the telephone and she's starting to bother him again. So Ben says, you are breaching a contract. What we have to look at here is both their intention to enter into legal relations. We are only discussing the C part here. Right. So all of this is not important. This is just explaining what a contract is. Let's look at intention of parties. Now, in order for there to be a contract, the parties must have the intention to enter into legal relations. However, there is a presumption. There are two presumptions when it comes to intention. First presumption is related to domestic agreements, and second presumption is related to commercial agreements. Commercial agreements. With domestic agreements, the presumption is that there is no intention to create legal relations. Commercial agreements, it is that there is an intention to create legal relationships. Now, in this case, this is a contract happening between two cousins. So that means it's a domestic agreement. So the presumption is that there's no intention to create legal relationships. So it's an agreement between two cousins, and thereby the problem is that blah, 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 blah. Presumption against intention to create legal relations in domestic context. So what is the case law that we have for it? We have two case laws, Balfour versus Balfour and Spellman versus Spellman. So let me explain the first case, Balfour versus Balfour. In this case, we have a husband and we have a wife. The husband is working in Ceylon or Sri Lanka, and the wife is in England. Now, the wife has a DC. So the husband gives a promise to the wife saying, I will send money for maintenance you because you are suffering and I am away from you and all of those things. Then they separate. There is a breakdown of this relationship and they separate. So they are no longer husband and wife. There's a separation. The wife claims that there was a contract between herself and her husband for maintenance monthly. The court says absolutely not. Because in a domestic relationship, the husband was simply making a promise as a husband, and that cannot be considered as a legally enforceable contract. So, if there is ever a case where there is a domestic setting where the mother makes a promise to a child, or a father makes a promise to the mother, or something like that, we say that there is no legal intention, right? However, there is, okay, let me take the other case as well, Spellman versus Spellman. In this case, what happens, again, we have a husband and a wife. We have a transfer of a car, right? The husband buys a car for the wife. The car is in the wife's name, but the car is with the husband, right? Then again, there is like separation and whatever happening. And the husband decides to keep the car. The wife demands the car to be transferred to her and she has to own it and all of those things. But in this case, the court says when it comes to property transfers, there is no legal contracts between parties because it is a domestic agreement. Now, this presumption that we have from these two cases is rebuttable, which means it can be, under certain circumstances, that presumption is removed. The case that we have for this is Merit versus Merit. Again, we have a couple. However, in this case, the couple is not husband and wife. Rather, they are separated. They are separated because the husband was living with another woman, right? So obviously there was like no love, care, anything like that between these two parties. The husband was with another woman and there was a contract between them. In this contract, it said that if the wife pays off the mortgage of the house, the husband will transfer the house to her, right? What was the contract? You pay the mortgage off in your house, I will transfer the house to you. Then the wife pays off the mortgage in the house, but the husband does not transfer the house to the wife. Here, the court said it was a legally binding contract. Why? Because the parties were negotiating at arm's length. What does that mean? They have broken the domestic relationship and now they're negotiating not as husband and wife, but rather as two parties making a contract. So let's say another example where the father has completely left the family and he meets his child someday and then they make a contract related to some business matter. Since the father was absent in this family and he's not making this contract with his son because he's his son, but rather because he wants a business partner or someone like that, we say that even though there is some sort of a domestic relationship, there is a there is an intention to enter into legal relationships between these two parties, right? Hopefully that makes sense. So in the case Merit versus Merit, the presumption was rebutted. Again, there's another case, Simpson versus Pace. What happens in this case is we have a family and we have a weekly competition related to like coupons and stuff, right? So they submit entries. They submit entries and these parties come to a sort of a contract which says if we win this contest and we get the prize money, we will share it equally. So they were all contributing to this entry, sort of relying on the fact that there was this contract, relying on the fact that, okay, if any one of us wins, we will get the prize money. So that's why they were all contributing. In this instance, even though this was a domestic setting, the court said there was a contractual relationship or intention to enter into legal relationships. Why? The rationale that they gave was the parties relied on each other's contributions rather than acting voluntarily. So, relying on the mutual agreement in doing this, right? They were not doing this because, oh, we just love each other and we are just entering into this agreement. No, they were wasting money on their end as well because there was an agreement to share the winnings from the entries. So when one party won and they were like, no, it's not a contract, we just made this in a domestic setting, I should be able to keep the money, the court said, no, you can't do that. Okay, so if we apply those principles to this case, Anushini can say, oh, well, the agreement is domestic. You and I are cousins. So, this was a domestic agreement. So there is no contract. But Ben can still say that we are negotiating at arm's length, right? We may be cousins, but this negotiation, this contract was at arm's length, and he can use merit versus merit. However, still, it's likely that Anushini will win considering the fact that Ben didn't sell it to her, right? Like if this was them negotiating at arm's length, Ben wouldn't consider about giving this to her for free, right? Like if you are not giving it to your cousin and you're giving it to someone completely strange, you would likely expect money from it, right? But because Anushini was his cousin, he didn't ask for any money. So we can say because of that, it reestablishes that this is a domestic relationship between them, and thereby this agreement, this is not a contract where there was intention of legal relationships, and thereby there is no contract. But does that mean Anushri can keep on pestering Ben and asking him for the what is that? The antique table? Yeah. She can keep on asking him for that because there was no legal contract between them. Hope that makes sense. Was there anything I messed up, Kasun?
No.
Okay. Right, that's it. Those are 3 questions, one to do with intention, offer, and invitation to treat, as well as acceptance. Hopefully that made sense to you guys. Thank you for joining the last 6 people that are here. Bye.
Thank you so much.
Okay, bye.